Good afternoon. Welcome to Pay Entry's weekly webinar. I'm Kathy Graham. I'm head of the HR services area at Pay Entry, and I want to welcome you today. Just a little housekeeping information up front. Number one, you do have a copy of this presentation in your handouts on the screen. And number two, if you have any questions throughout this presentation, please type them into the questions box. We will be answering all questions at the end. Also, our webinars are intended for educational purposes only. I wish I were an attorney, but I'm not. So while we hope the information presented is helpful to you to understand the topics that we're talking about, please remember that I am not an attorney and I am not giving legal advice in this presentation. Okay, today we're going to do something fun. I like this webinar more than some of the others that are just, you sit back and listen. You're going to participate in this today. I want you to get a piece of paper and number it from 1 to 20 because you're going to take a test. And next time I do this, maybe I'll send that little test paper out in front of the presentation. But today I need you to get a piece of paper, write down 1 through 20, and I'm going to ask you some questions, because if you're responsible for setting policies and establishing HR rules in your company and administering them, then you really need to know some of the basics of human resources to make sure that your company is not getting themselves in trouble by being non-compliant. So, how good is your knowledge? We're going to start this little quiz now. There are 20 questions. I'm going to show you the question and then I'll show you the answer. First of all, let me ask someone to type in the questions section to make sure that you can hear me. Can everyone hear me and see the screen? Okay, thank you very much for telling me that. That helps. All right, so what you don't know can hurt you. Let's start off with posters. Your company is in the manufacturing industry. So which of the following posters is not required to be posted in your workplace? Is it the Employee Polygraph Protection Act, the Fair Labor Standards Act, the Health Insurance Portability and Accountability, or HIPAA Act, or USERRA, Uniformed Services Employment and Reemployment Rights Act? I'm going to give you just a minute to write down your answer. Which poster is not required to be posted in your workplace? Okay, the answer is C, HIPAA. You do not have to post the Health Insurance Portability and Accountability Act in your facility because you're a manufacturing facility. HIPAA applies to those who are who house PHI, Protected Health Information. So those would be considered covered entity. Covered entities. A manufacturing facility is not a covered entity. So, but if you're in a doctor's office or a hospital, you might see that poster because it is important for their employees to know that they have to follow that. All right, let's go on to the next question. Which employers must comply with COBRA? Is it employers with a minimum of 20 employees that offer health care? Is it employers with a minimum of 50 employees that offer health care? Is it all employers that offer health care? Or is it only self-insured employers that offer health care? I'll give you a minute. A, B, C, or D. COBRA is the law that applies to health insurance and continuation of that insurance. And it's not just health insurance. It applies to your dental plan and anything related to medical, dental, vision, and medical. And FSAs and HRAs, actually. Okay, the answer to this question and I know you're getting all these right, is A, employers with 20 or more employees that offer health care. And to fine tune this just a little bit, the 20 head count is calculated in the prior calendar year. So if you had 20 or more employees in the prior calendar year, then you need to offer COBRA if you offer health care. Now, there's a little catch to this too, because if you have less than 20 employees, you may still have a state mandated continuation plan or coverage. So you need to make sure that you're complying with that. If you don't have 20 employees, then you don't have to comply with the federal COBRA laws. But there are state mini COBRA laws that do apply in most states. Okay, here's another question for you. You have an employee who's been classified as an exempt employee. They earn $45,000 a year and are not entitled to overtime pay. This person is a welder in your manufacturing division. Is this person classified correctly under the Department of Labor's wage and hour laws? Give that just a little bit of thought. So you have a welder and you have deemed that they are exempt, which means that they will not get paid overtime. Okay, the answer to this question is no. That person cannot be exempt because the exemptions that are provided by the Fair Labor Standards Act apply only to white-collar employees who meet certain salary and duties tests set forth in regulations. The exemptions do not apply ever to manual laborers or other blue-collar workers who perform work involving repetitive operations like press operators and machine operators. If it requires physical skill and energy. So that would also be construction workers and people who are doing certain things outside that, like installing cable. Those people will never be exempt under the law legally because they are considered blue collar. So it covers non-management employees in production, maintenance, construction, and similar jobs. So I hope you got that one right. I have worked with a company that has a welder. That's where I got the example that the boss decided needed to be salaried, so they made him salaried. And sometimes in companies, HR people can't do anything about it. If they don't own the company, they lose a little bit of that authority sometimes. All right, here's your next question. You have 10 employees and your company does not have an employee handbook because the owner feels like your company's too small and everybody already knows the rules. Is this practice legal? Give you a few minutes to answer that. Or not a few minutes, just a few, maybe 30 seconds, because I know you are all right on top of this. So is this practice legal? Well, yes, it is. You don't have to have a handbook. There are no laws that say you have to have a handbook. But if you don't have a handbook, you're putting yourself at risk for not everyone knowing the rules. And if the rules aren't set forth in a handbook or somewhere, and you want to terminate somebody because they violated a policy that they didn't know about, then you can't do that. Also, you have people working on different levels that don't understand what the rules are, and that can really cause some problems. So you don't legally have to have a handbook, but it is a good idea to have one. And but if you're going to have a handbook, you need to follow it. I would say if you're not going to follow the handbook rules and policies, then don't create a handbook. But if you have a handbook, follow it. Next question. Your company must comply with the Family Medical Leave Act. If an employee is not physically able to return to work at the end of their leave, can you fill their position and terminate that person? Yes or no? Okay, give you just a few seconds to do that one. Yes or no? Okay, the answer to that is no. You must first consider the situation and see if the person or determine if the person has a disability that might need to be accommodated prior to the termination of the employee. The Americans with Disabilities Act would come into play here. Depends on what the situation is, whether or not the person is disabled and whether or not it is something that you can accommodate. So you should not fire someone that doesn't return from a leave. Now, I'm not saying if they just don't show up and they said they were going to, that's a termination offense. That's job abandonment. But if the person says, I can't come back yet, then you need to have a response there. And you need to take a look at whether or not you can accommodate that person. The next question, you're required to pay employees, this is a statement actually, you're required to pay employees who work on a holiday 1.5 times their normal rate of pay for work on that day. Is that yes or no? So you have to pay overtime on holidays. Is that yes or no? Now, some of these questions are a little quirky based on state laws, but I'll mention that in a minute. Okay, the answer to that is no. Unless you have a state law like Massachusetts that has a specific rule about retailers, then you are not required to pay any more than straight time on a weekend if it's not considered overtime, like over 40 hours that week. All right. I hope you've got 100 so far. Which of the following can you not ask in an interview? So A, where did you go to school? B, what kind of experience do you have in this field? C, do you have children? And D, how much did you make in your last job? Which of these 4 can you not ask? And this is on a federal law level. A, B, C, or D? Oh, sorry, and E, what are your hobbies? Forgot one. So A, B, C, D, or E, what are your hobbies? Well, the answer is C and D, actually. So if you picked one over the other, that's fine. Do you have children? And how much did you make in your last job? Now that's based on certain states. Certain states have some rules about criminal background checks that you can't ask about, and how much did you make in your last job, because it has a tendency to hold those who are earning less back from, well, like women who are earning less in the marketplace, holds them back from the pay level that they should be in. So it impacts pay equity. And you can't ask them if they have children, because that means it might come up in the conversation. But if you ask them, do you have children? Do you have childcare? That's really not a good answer, because you're treading a fine line there. It has nothing to do with the job. And you might ask that of a female and not a male, and that would definitely be a problem. The next question is more of a statement. You have 35 full-time employees and you have 10 part-time employees. Which of the following federal laws apply to your company? The Civil Rights Act of 1964, the Fair Labor Standards Act, the Family Medical Leave Act, the Affordable Care Act, and the Americans with Disabilities Act. Which of the following federal laws apply to your company if you have 35 full-time employees and 10 part-time employees? I'll give you just a few seconds to guess at that one. And most of you I know are not guessing. You'll get them all right. Okay, let's look at the answer to that. The answer is A, B, and E. The Civil Rights Act of 1964, that's if you have more than 15 employees. The Fair Labor Standards Act, if you earn more than $500,000 as a company and or cross state lines. The Americans with Disabilities Act, which is for 15 employees. Whoops, back up here. So those are the 3 that would apply to you. Now, I'm going to go back to this slide before and just look at the ones that don't. The Family Medical Leave Act does not apply to you, neither does the Affordable Care Act. Family Medical Leave Act applies to employers who have 50 or more employees within a 75-mile radius. And the Affordable Care Act is if you have 50 full-time equivalents in the prior calendar year. So we'll skip back this one right here and go on to the next question. Which of the following do I use to determine if an employee is hourly or salaried? That's exempt or non-exempt versus exempt. The number of hours that they work, their job title, their job duties and responsibilities, how much they earn, how long they've worked for you. So which of the following do you use to determine if someone is exempt or non-exempt? Okay, let's go on to the answer here. The answer is C and D. Their job duties and responsibilities and how much they earn. It does not make any difference what you call somebody, what their title is, who they report to. There are a lot of administrative assistants in the world and secretaries that are considered salaried that probably shouldn't be because of the level of responsibility and responsibility that they have. So if you look closely at the administrative exemption in the law, it rules out pretty much those individuals or those types of positions. Let's go on to the next one. Okay. Which of the following should not be stored in an employee's personnel file? Is it the application for employment? What about their references? What about the I-9 form and their attendance records or their training schedule? And last, what about performance appraisals? So which of the following should not be in a personnel file? And we're not going to talk about this today, but in each state, there are rules about when an employee can access their personnel file and whether or not they can have a copy of that. And you should know that also. It's not one of the questions, but it is something that on a state-by-state level you need to know, especially if you are in multiple states. Okay, let's look at the answer to this one. The answer is C. Definitely do not put the I-9 form in your personnel files. It's not really because of the information. You want to keep this information away from anyone who doesn't have a need to see it. And also, if you're ever audited, you do not want you do not want ICE or whoever comes to audit you to be in your personnel files. Number one, the rule is if someone comes to audit you, whether it's the Department of Labor or it's a tax division of the IRS, they will refer to other departments if they find things that look out of whack. So an I-9 form should never be stored with the personnel file. It should be kept in a separate file with all the other I-9s. You can keep them alphabetically, numerically, or whatever you want to do, but don't put it in the personnel file. Okay. Is it true or false that federal law requires that employers pay sick time for full-time employees? This should be a pretty easy one. Does federal law require that? Well, the answer is false. So you do not, you don't have to pay employees, any employees, exempt or non-exempt, if they're not working. Okay, next question. Is it illegal under federal law to require a salaried employee to complete a timesheet? Is that true or false? I get questions about this sometimes. If they're exempt or salaried, should you have them complete a timesheet? Well, it's false that it's a law because hours worked may need to be tracked for purposes of benefit eligibility like retirement plans, client billing, FMLA, or vacation or sick accrual. So you can ask for a timesheet, but the salary should not fluctuate based on the hours worked unless it's allowed under the law. And there is a fact sheet. Fact sheets are published by the Department of Labor to specifically give you information on a particular topic. 17G is the one that talks about how an employee's salary can fluctuate if they are hourly. Salaried. For absences, usually for absences of 1 or more full days due to sickness or disability, under a sick leave plan that you have at work, is one reason you can deduct a full day of pay. If they're out of sick leave, you can deduct a full leave of pay, a day of pay. Or if you have a disciplinary suspension of 1 or more full days, or if they're coming in the middle of the week as a new hire, or they're leaving in the middle of the week as a termination, you don't have to pay for that full week, only the days worked. Okay, next question. I-9 forms must be completed within 30 days of an employee's first day of work. Is that true or false? This should be a really easy one for everyone. Okay, the answer is false. Employers must complete and sign Section 2 of Form I-9 within 3 business days on the date of hire of their employee. The hire date means the first day of work for pay. So you can't wait 30 days, can't wait 20 days. You have to do it within the first 3 days of them beginning to work. This is the regular rate of pay must be used in paying overtime. That's a statement, and it includes which of the following. So which of the following are considered as a part of the regular rate of pay? Non-discretionary bonuses, discretionary bonuses, commissions, tuition reimbursement amounts, earned vacation. So which of the following must be used in paying overtime and are included in what we call the regular rate of pay? This is one of the most misunderstood laws and violated laws because a lot of companies don't know this. Okay, let's look at the answer. It's A and C. Non-discretionary bonuses and commissions must be considered when you're calculating the regular rate of pay for overtime calculations. If you need more information on that, we did a webinar, I think at the end of last year, and you should be able to access that on our website about how to pay overtime. The next question is workers' compensation does not pay an injured employee for the following. Is it lost wages, health insurance premiums, or medical bills? What does it not pay an employee who is injured? Okay, this is health insurance premiums. It pays for lost wages with a specific waiting period along with associated medical bills. This varies by state also, so you should know the different levels of pay and waiting periods in each of the states that you're in, because it does vary by state. The next question is employers with more than 50 full-time equivalent employees are required to file reports annually with the IRS under the Affordable Care Act showing health care has been offered to employees. Is that true or false? And I think that we had a prior question that already answered this one. So I'll have to mix this one up next time. But if you have more than 50 full-time employees or full-time equivalent employees, that's adding your full-time and your part-time together based on hours worked, are you required to file annually? True or false? Well, the answer to this is true. Employers with 50 or more FTEs in the prior calendar year are required to track and report coverage offered to full-time employees. So if you had more than 50 last year, then you have to report this year. If for some reason this year you don't have an average of 50, then you won't have to report next year. Is this true or false? Employers are not obligated to pay overtime when the hours were not pre-approved or authorized by management. Is that true or false? And I bet I've got 100% right answers on this, I'm sure. Okay, the answer is Easy. The wage and hour division of the Department of Labor requires that all hours worked be paid regardless of approval status. If somebody works time and you have a policy of them not being able to work time unless they've had it approved and they do it anyway, you have to pay them the hours, but you can write them up. It would be a disciplinary issue. Working off the clock is not permitted under the Fair Labor Standards Act. And you should really discourage managers and supervisors from even thinking in that direction. Is it okay to let an employee take time off later if they work overtime this week, for example? Is that true or false? Okay or not? Well, it's not okay. In the private sector, there's no such thing as comp time for non-exempt employees. So if you have an hourly employee that works more than 40 hours this week, you have to pay them overtime. You can't give them time off in the next week because, and I think there are some FLSA exemptions for this if you work a different type of work schedule. I'm not going to go into detail on that, but there are a couple of exemptions to this, but in general, hourly people should not get comp time. It can be in the same, unless it's in the same week. If they worked over 8 hours in one day and you let them go home early the next, so they don't get over 40 for the week, you can do that. But that's not really comp time. That's just shifting the schedule. The Fair Labor Standards Act supersedes state and local overtime laws. Is that true or false? So if you have a state law, which one is stronger? The answer to this is false. State and jurisdictional laws take precedent over federal laws. And I probably should have a category, it depends. But a lot of things in HR depend. You'll get an answer, well, it depends. Well, it depends. If your state has a law that is more beneficial to the employee, then you have to use whichever of the laws is greater. So state or federal or jurisdictional, whichever is the better benefit to the employee, that's the one that you have to follow. And that gets so confusing and very hard to keep up with nowadays because a lot of states and a lot of even counties and cities are putting in individual laws for laws that already exist at another level, but they're just tweaking them just a bit. So it's very hard to keep up with all of that. Is this true or false? You can hold an employee's final pay until they turn in all their equipment and uniforms in their possession. Is that true or false? Well, this is false. And that's not what the boss always says. I'm not going to give them their check until they give me my saw back or my tool back. Many federal and state laws actually prohibit or hinder deductions from final pay. So make sure you look up your state, make sure you know what your state requires before you ask for that. And regardless, I think you'll find that you have to have a written permission to make any deduction from an employee's paycheck. So if they have signed something in advance with a specific amount and that they agree to pay it back if they leave, then even that sometimes doesn't stand up in courts. So be careful with that. So how did you do? We went through the 20 questions in 30 minutes. I know that's a little fast for some of the questions, but how did you do? How many correct answers did you get? I want you to total it up. And I'm not going to ask you to raise your hand, all right? But I want to make sure that you feel comfortable with your scores. So, and now we're going to have some questions here. If you don't feel good, this was not meant to make anyone feel stupid. What it was meant was to show that sometimes it's hard for you to keep up with everything. And you may not know everything that you don't know, That's the dangerous part. If you don't know it and you think you do, or you don't even know that that question would exist in the first place, then it can be a problem. So let's see if we have any questions here. I think this question might have been about COBRA. Is that 20 full-time or 20 total employees? That is 20 total employees, not full-time. Okay, under COBRA. Someone that did not know that I-9 should be kept separate from the employee files. Is that electronic and paper files both? Yes. If someone would come in and audit you, you don't want them in all your files. You want them to only be going to one place for the I-9s, and so that they're not in either, whether it's electronic or paper. Keep them in separate folders. Someone wants to know where they can find the fact sheet 17G. Just type in FLSA and 17G, fact sheet 17G, and it'll come up on the internet. If you can't find it, I will send it to you. As far as the salaried workers, I have a question. How many hours can they work over their 40 hours? There is no limit. Salaried worker is hired to do their job. And if their job takes 50 hours a week, then 1 week, and then it doesn't take 50 hours, maybe it only takes 32 the next week, their hours may fluctuate, but there is no limit to how many hours over 40 they can work. Okay, any other questions? Well, one thing I did want to offer you, two things. I meant to put a slide up here. We have a new APHR class starting up on March the 8th. APHR is the first level of certification for the HR CI or HRCP organization, HRCI, which gives you an HR accreditation or a certification. We start our new class on March the 8th. It is at night on Tuesdays for 6 weeks. And if you're interested in getting more information on that, just shoot me an email. Also, if you decide that you can't handle remembering all of your state information and you need more information, contact us, hrservices@payentry.com. We're here to answer your questions. As a part of your basic payroll package, you can ask us, you can call or email us and ask us questions. And then we have another level of service called HR Services. We have a compliance package under HR Services that you can actually contract with us to do things like bring your company into compliance from an HR standpoint. If you'd like more information about that, I'd love to share it with you. But if you need more information on any of the questions we've asked today, just let me know.